Good afternoon. I'm Jared Bryant. I'm a partner and the office leader of Faegre, Drinker, Biddle, and Reath's Denver office. We as a firm are really honored and excited to continue to work with the law school to host this year's installment of the U.S. Supreme Court Review. And we're especially excited to see the turnout today and to be able to reach a much larger virtual audience. In fact, we understand that there's approximately several hundred people joining us for the presentation today, both across the country and even internationally. So a big thanks to each of you for taking the time to join and to participate. I'd like to kick it off first by introducing the moderator of our panel today, Dean Lolita Buckner Inniss. And just a little bit of background on Dean Inniss. She's the very new Dean of the University of Colorado Law School and is also the Provost Professor of Law. Before coming to CU Law, she served as Senior Associate Dean for Academic Affairs and a Professor of Law at SMU Dedman School of Law. At SMU, Dean Inniss was a University Distinguished Professor and a Robert G. Story Distinguished Faculty Fellow. Dean Inniss received her AB from Princeton University, where she majored in Romance Languages and Literature with certifications in both African American and Latin American Studies. She earned her JD from UCLA, where she was an editor of the National Black Law Journal and a moot court honors participant. Dean Inniss also holds an LLM with distinction and PhD in law from Osgoode Hall Law School, York University in Canada, where she won the Mary Jane Mossman Award for Work in Feminist Legal Theory and the Harley D. Hallett Award, and was a Peter Hoag Scholar and a graduate assistant of the Institute of Feminist Legal Studies. So with that, welcome Dean Inniss, and I'd like to go ahead and turn it over to you to serve as the moderator of our panel today.
Thank you so much, Jared Bryant, for that very kind introduction. And thank you also for Faegre Drinker's support of this endeavor. I'd like to once again welcome you all to this virtual edition of the Colorado Law U.S. Supreme Court Review. As was just mentioned, to reach a larger audience, we are, as was true last year, presenting virtually. We are so really pleased and honored to host the Colorado law community of alumni, students, faculty, staff, friends, as well as members of the law community locally, nationally, and even internationally. Just a few brief words about the U.S. Supreme Court term that most recently passed. The court agreed to hear 62 cases in this just past year. And it's noteworthy that 12 of those cases were originally scheduled for the previous year, the 2019-2020 term, but were delayed due to the coronavirus pandemic. All of the cases, perhaps not surprisingly, were heard remotely. I also want to offer a few words about geography and the court. As many of you know, there are some circuits that are perennially very much represented among the court's cases. So of the 62 cases that were heard in this most recent term, the vast majority of them came from the Ninth Circuit, which is fairly common. There were 14 cases from that circuit that the court agreed to hear. The Third Circuit, the Fifth Circuit, and the DC Circuit were next. They were tied with 6 cases each. I think it's also worth mentioning that our own circuit, Colorado, the 10th Circuit, there were 10 cases that the court heard. And then finally, I might note that 2 of the court's cases came from the court's original jurisdiction, which, as many of you know, that's usually a fairly small amount of cases where states are vying with one another. So those are also typically pretty interesting as well. Today, we're going to hear from several esteemed members of the legal profession as they share with us their perspectives on some of these recent cases. We have with us today University of Colorado Law Professor Helen Norton, Colorado Solicitor General Eric Olson, Attorney Aaron Van Oort of Faegre Drinker, Biddle, and Reath, and Attorney Shannon Wells of Stevenson of Davis, Graham, and Stubbs. Participants have detailed presenter and moderator biographies that were emailed and available with the link posted in the chat. Now, each presenter is going to offer some opening remarks and brief comments, but one of the things that we're hoping to encourage today is a lot of, or at least as much as possible, organic interaction between and among the panelists. We're also going to save some time at the end for there to be some audience reaction. One of the things that you will see at the bottom of your screen is a Q&A function, which I'll be monitoring. And so we're hoping that you, members of our audience today, will also pose some questions for our panelists to take up. And so without any further ado, I turn the program over to our first panelist, Professor Helen Norton.
Thank you so much, Dean Inniss, and thanks to all of you for sharing your lunch hour with us. I'm going to focus on two of this term's First Amendment decisions, and then I'm going to turn to its voting rights decision. I'm going to share my screen with you. So first, Mahanoy versus BL is the court's first foray into whether and when the First Amendment permits public schools, public elementary and secondary schools, to discipline students for their off-campus speech. And it turns out that the court's answer to this question is sometimes. Here we have a public high school student who tried out for the varsity cheerleading team and for the softball team. She was instead selected for the junior varsity, and she was unhappy with this. So she posted on Snapchat while she was off campus and outside of school hours. She posted a photo with her and a friend with their middle fingers raised and with the caption F school, F was followed by 3 other letters, F school, F softball, F cheer, F everything. And in response, the school suspended her from the cheerleading team for a year on the basis that her posts used profanity in violation of school and team rules. The student alleged that this violated her free speech clause rights, and an 8-to-1 court agreed with her. So just a little bit of background, a reminder on the court's approach to student speech leading up to this case. In Tinker, the court famously stated for the first time that public elementary and secondary school students do not shed their First Amendment rights at the schoolhouse gates. And there it upheld Mary Beth Tinker's First Amendment challenge when her school punished her for wearing a black armband in protest of the Vietnam War. Now, at the same time, the court held that the First Amendment permits schools to punish student speech when the student speech is substantially likely to cause material disruption or when it collides with the rights of others. And it found that the school had made no such showing in Tinker. Now, since Tinker, the court has understood the First Amendment to permit public school administrators to punish student speech in 3 other contexts, once involving a student's speech to the student body that was laden with sexual innuendo, another involving what the school felt was controversial material in the school newspaper when onlookers would understand that newspaper, that speech to bear the school's imprimatur, and another involving speech that the school understood to encourage illegal drug use. In recent years, lower courts have split in multiple different ways on the question of whether and when the First Amendment permits public schools to punish students off-campus speech, which is what brings us to Mahanoy. Now again, an 8-to-1 court held for the student, and in so doing, however, it rejected the Third Circuit's absolutist rule below. The Third Circuit had held that the First Amendment protects all off-campus student speech from school discipline. Instead, Breyer's majority opinion declined to set forth any general rule and indicated that the First Amendment sometimes permits public schools to punish students off-campus speech. But not in this case, where the majority was unimpressed with the school's asserted interests in teaching good manners, in preventing disruption, or protecting team morale, especially since there was no evidence of disruption or morale impact. So Mahanoy represents students' First Amendment win in the Supreme Court in more than 50 years since Tinker. Now, Justice Breyer's opinion is characteristically pragmatic. He acknowledges both the First Amendment value of students' off-campus speech, as well as the practical realities and challenges that face school administrators. On the one hand, he identified bullying and harassment, targeted threats as the sort of off-campus speech that could justify school discipline consistent with First Amendment. On the other hand, he said that schools have even less First Amendment leeway to regulate off-campus student speech than on-campus speech, not only because the students themselves have free speech interests, but also because, he stated, the school itself has an interest in protecting a student's expression because America's public schools are the nurseries of democracy. Justice Thomas was the sole dissenter, and he reiterated his originalist belief that the free speech clause does not protect children's speech. Okay. Moving to the Free Exercise Clause, and a little bit of background. Longstanding consensus for the proposition that the Free Exercise Clause protects religious conduct from the government's intentional interference or discrimination. At the same time, deep divisions over whether and when the Free Exercise Clause prohibits government regulations that have the effect but not the intent to interfere with religious practice. In other words, deep divisions over whether the Free Exercise Clause requires the government to exempt religious practice from otherwise applicable law. The court veered back and forth on this question for a couple of decades until 1990, an Employment Division of Oregon versus Smith, a 5-4 decision written by Justice Scalia. And there the court held that the Free Exercise Clause does not require the government to exempt religious practice from laws that are neutral and generally applicable. And there the court upheld Oregon's refusal to exempt the religious use of peyote from its general ban on drug use. And this is consistent with Justice Scalia's general deference to government in Religion Clause cases. He was slow to see Establishment Clause violations, and he was slow to see Free Exercise Clause violations. This is what you might call a majoritarian approach that gives the government the latitude to choose whether or not to support or promote religion, and to choose whether or not to give religion special treatment. Now, Smith did hold that strict scrutiny applies when the government interferes with the religious practice through a law that's not neutral, not generally applicable. And this is the case, for example, when the government intentionally targets or discriminates against a particular religion or religious practice. So this brings us to Fulton versus City of Philadelphia.
Helen, I wonder if I could add a Scalia anecdote here.
You bet.
The transition. So many of you know I clerked for Justice Scalia 20 years ago or so, and part of that is an interview process. And part of the interview process, it was well known, is that you had to be ready to talk with the justice about one case of his that you disagreed with. And I got very, very clear advice that I should not raise Employment Division versus Smith, because everybody raised that with him on that. And he was really, proud of it and really irritated if you brought it up. And so I think I remember I talked about some helicopter crash case or something, but it was really interesting. In addition to what you say about deferential to the government, I always read this case from him as he really liked clear rules. And he liked things that could be applied across the board, and he hated balancing things or things that would make you do a lot of applications or detailed consideration of facts. And so I always thought this came out of there. It'll be really interesting, and you may comment on this, what another of his former clerks now on the court, Justice Barrett, is going to do with his opinion here when she's pressed to it.
Thanks, Aaron. I think it's definitely true that helicopters are less controversial and less interesting a topic than religion in pretty much any conversation.
I definitely played it safe.
So in Fulton, the City of Philadelphia, here's the background. It enters, like many jurisdictions, into annual contracts with private foster care agencies to place children with foster families. And then these contracts require the agencies to certify prospective families under state statutory criteria. Catholic Social Services, CSS, is a longtime participant in this program, and it believes that certifying same-sex couples as foster parents would require them to endorse same-sex relationships in violation of their religious beliefs. The city informed CSS that its refusal to certify same-sex couples violated the contract's non-discrimination clause, among other laws. And CSS challenged the city's action on Free Exercise Clause grounds, urging, among other things, the court to overrule Smith and announce a new rule in which it would apply strict scrutiny anytime the government declines to exempt religious practice from generally applicable law. In Fulton, in an opinion written by Chief Justice Roberts and joined by Barrett, Kavanaugh, Kagan, Breyer, and Sotomayor, so this is a total of 6, the court declined to reconsider Smith, but held that Philadelphia's contractual non-discrimination clause was not generally applicable as required by Smith because it permitted exceptions at the sole discretion of the city's Department of Human Services. Now, this discretion had never been requested in the past, much less exercised, but the court found that the existence of this mechanism for discretionary exceptions meant that the non-discrimination clause was not generally applicable. So the court unanimously ruled that where you have such a system of individual exemptions, the government may not refuse to extend such exemptions to religious practice absent a compelling reason. And here the court found that Philadelphia had no compelling reason for refusing to exempt CSS because, according to the court, its system for discretionary exemptions undermined the city's claim that it could not permit departures from the non-discrimination principle. Now, as Eric's going to discuss in a few minutes, in a case on the court's shadow docket this past term, the court identified another way in which a law lacks general applicability and thus triggers strict scrutiny under Smith. Justice Alito was joined by Justice Thomas and Gorsuch in writing a 77-page opinion that concurred in the judgment. So there's a unanimous court finding a free exercise clause violation here, but lamenting the majority's failure to reconsider and overrule Smith. And again, if the court were to overrule Smith, this would require courts to apply strict scrutiny anytime the government declines to exempt religious practice from generally applicable law, which would mean, as a practical matter, lots more religious exemptions. Now, in a very interesting move, Justice Barrett wrote a short opinion that concurred with Roberts' majority opinion as well as its judgment. In the first paragraph of her opinion, and this paragraph was joined only by Justice Kavanaugh, she noted that she has concerns about Smith, about its textual and structural soundness. But then the rest of her opinion, which was joined not only by Justice Kavanaugh, but also Justice Breyer, identified a number of pragmatic concerns about the difficulties, doctrinal and pragmatic, of substituting Smith with a categorical strict scrutiny rule. And for this reason, she saw no reason to reconsider Smith at this time. So we don't know if there are any more than 3 votes, Alito, Gorsuch, Thomas, to overrule Smith, but certainly we will find out.
Didn't Justice Barrett sound just like a law professor in that, in her concurring opinion? It's like, oh my gosh, you could just see her standing in front of a classroom saying almost exactly what she wrote and spotting all of these problems. At least that's the way it struck me. I don't know how it struck you.
I hope you think that's a positive thing.
Yeah, it's interesting. I think she'll go through a transition. You know, professors typically, early on in their careers, they spot all sorts of issues and do that in their opinions. And eventually they get weighed down by the burden of proving that they're right. And they tend not to be so open. Or at least that's the progression I've seen in professors becoming judges. It seemed to me that she was still very much thinking as a professor and not as much as a judge yet.
I don't know that.
A good thing.
I don't know that those roles are mutually exclusive. And I like to think that professors, like judges, are complicated and diverse human beings. So I don't know that she has to shed one or the others of those personas. So let me turn to the Voting Rights Act, the court's decisions interpreting Section 2 of the Voting Rights Act and upholding 2 Arizona voting restrictions. A little background on the Voting Rights Act. First enacted in 1965 at the height of the civil rights movement. Section 5 of that act required certain jurisdictions, mostly in the South, with a specific history of discriminating against voters of color, required those jurisdictions to get federal preclearance from the Department of Justice before they changed their voting rules to make it harder for folks to vote. But in 2013, in Shelby County versus Holder, a divided court invoked federalism principles to strike down the Section 5 formula used to determine which jurisdictions had to get pre-approval, and what this meant is essentially rendered Section 5 inoperable. The majority acknowledged this, acknowledged that it had just taken Section 5 off the table as a functional matter, but it noted that Section 2 remained available to challenge state and local restrictions on voting rights. But up until that time, Section 2 had been used almost exclusively in redistricting cases, which involved challenges to redistricting maps, challenging that they unlawfully diluted the votes cast by voters of color. Here, the court is considering for the first time Section 2 challenges not to voter dilution cases, but instead to laws that actually restrict voters' ability to cast ballots as an initial matter. And here's the key statutory text for Section 2, most recently amended in 1982 and expressly designed to prohibit both intentional discrimination against voters of color and also disparate impact discrimination, right? Where there's not necessarily a jurisdictional intent to discriminate, but the effect is to disproportionately exclude voters of color without adequate justification. In the cases that it heard this term, Brnovich and the companion case, the court considered two voting laws, Arizona voting laws. One was its out of precinct rule that required officials to completely discard any ballot cast in the wrong precinct. So under this law, if you went to a precinct, your name wasn't on the rolls, but you think, oh no, I'm supposed to be here, you get to cast a provisional ballot, but the ballot will be discarded if it turns out later that you voted in the wrong place. Even your entire ballot is discarded, even if you were eligible to vote for governor or president, which does not turn on which precinct you vote in. The other provision makes it a felony for most people to collect and deliver other folks' early ballots, with exceptions for postal workers, caregivers, and the like. And challengers allege that both laws have a disproportionate impact on Black, Latino, and Native American voters in violation of Section 2. The out of precinct rule meant, on the one hand, that a relatively small number of ballots were discarded under the out of precinct rule, but under that rule, the ballots of voters of color were discarded at twice the rate as those for white voters. And with respect to the ballot collection rule, the challengers noted, among other things, that Native Americans in remote locations have limited mail service such that they disproportionately rely on others to collect and deliver their ballots. Justice Alito wrote for a 6-justice majority. He upheld both laws against the Section 2 claims, and he identified what he called as guideposts to illustrate why he felt the Arizona laws passed muster. Justice Kagan, former professor, wrote a sharp dissent joined by Sotomayor and Breyer. And there's a tense back and forth between her opinion and Alito's. And one of their primary disagreements, and the one that's most interesting to me, is over the role of history in statutory interpretation, especially in anti-discrimination law. And Justice Kagan details at length the history of voting discrimination in America. She starts with the enslavement and disenfranchisement of African Americans, efforts to correct that with the 13th, 14th, and 15th Amendments, the continuing persistence of voting discrimination, and efforts to correct that tenacious history with the Voting Rights Act. So she started her opinion by observing that the Voting Rights Act represents the best of America, but also reminds us of the worst of America because it was and remains so necessary. Justice Alito, in his opinion, states that this is a history we should all remember, but he says this history does not tell us how to deal with these cases. Kagan disagrees and argues that the history of discrimination that inspired the Voting Rights Act should inform the acts of interpretation, and that we should understand the act as intending to disrupt and challenge the status quo, that courts should be searching and demanding, not deferential, when they consider new voting restrictions. So what remains to be seen, and what everybody's interested in, is what these decisions mean for ongoing voting rights litigation in Georgia and elsewhere. I look forward to what my colleagues have to say.
Thank you so much, Professor Norton. We now will turn to Solicitor General Eric Olson.
Thank you very much, Helen and Dean Inniss. A real hearty welcome from all of us to Colorado. We're so glad you're here at the University of Colorado and look forward to your leadership. But thanks for all you do and will do for the great institution. I'd like to talk today about what I call advocacy lessons from the Supreme Court's term in terms of things that all of us who don't necessarily practice in front of the court can learn. And I'm going to talk about two things or two categories of cases. The first is the shadow docket that Helen mentioned briefly. And the second is just a quick discussion of the NCAA v. Olson case. Both cases are ones that our office had some engagement with. And I think that engagement can shed some light on and give us lessons that all of us can learn from. So first, on the shadow docket, what is the shadow docket? And it's really the cases that the court decides that aren't the merits cases where they grant cert, have oral argument, and issue opinions in due course. These are typically emergency applications that occur to the court. In years past, they primarily were cases related to state death penalty executions. and last minute applications there. Under the last presidential administration, there was a significant uptick in the use of the shadow docket by the Solicitor General, and that encouraged other parties to do it as a much more robust practice now. And the way it really works is you can file an emergency stay with the court. You get a phone call from Mara Silver, who's the emergency stay clerk at the court, often telling you that a response is due within a few days. And then the court issues an opinion very quickly, not necessarily a signed opinion. There's very few guidelines as to what criteria the court uses, and it's a really informal and fast-moving form of decision-making by the Supreme Court. And I'd like to talk about 4 shadow docket cases this year, 2 of which, the ones in white, were ones that Colorado was involved in. All 4 of them relate to religious entities who were seeking the Supreme Court's intervention to prevent state COVID restrictions from applying to them. The Roman Catholic Diocese came out of New York. High Plains, as I said, was here in Colorado. Tandon was the case that came out of California, and Denver Bible was a case from here in Denver that occurred. And as you can see, the file date is when the petitions showed up at the Supreme Court. And then what would typically happen is you would get a phone call from Ms. Silver, and one consequence unforeseen to me of this practice is that understandably, Ms. Silver blocks her telephone number, so it comes in as potential spam on your phone. But for the past 9 months, I've answered almost every potential spam call that my phone receives, because you never know when it's the Supreme Court. But I've learned much more about my car's expiring warranty than the Supreme Court. But a few times it was actually her, and typically says things like, hey, Justice Gorsuch is going to request a response. In High Plains, we had 5 days. In Denver Bible, I was able to negotiate a little more time because we had been nice to each other over the course of the year on these shadow docket cases. And then, as you can see, we file a response, or the state files a response in all 4 of these cases, typically within 5 or 6 days. And then the court issues an opinion very shortly thereafter. And in the past, sort of the general rule has been that the court doesn't make new law in the shadow docket, that what it does is really just apply existing law to emergencies that are coming to the court. But that's really changed. And so I think the best way I describe advocacy, particularly as a state defendant before the shadow docket, is very similar to Obi-Wan Kenobi in Star Wars, where you just try to convince the court that this is not the case they're looking for, to make the change in the law that they seem to be wanting to make. And in our cases that we dealt with, it all dealt with the application of this rule from Employment Division v. Smith that Helen and Aaron talked about. But is it a valid and neutral law of general applicability? Generally, you don't get a sort of an exemption for, unless you can show that it was done to target religion or religious conduct. But what the court did in these cases, again, the 4 cases here, is really change the settled application of that law to what it means, all in the COVID context. And it first started in the Roman Catholic Diocese there. It threw out New York's approach to limiting the size of religious gatherings. And so then in High Plains, when it showed up at our, on our phone saying we have a response due, and it came straight from the district court, I believe. High Plains did. It was a stay application filed. So we worked very hard to make sure that when we filed our motion on December 9th, our response, that we could show the Supreme Court that we were listening, that we understood the rules had changed, and that we had gone to great lengths to ensure that religious institutions were treated as the court now required under the Free Exercise Clause, under the COVID restrictions. And so the ruling on December 15th was they did what's called grant, vacate, and remand, and sent it back to the 10th Circuit, where we settled with no further change in our law, because we had really worked hard to make sure that by the December 9th filing, we could show the court, not just tell the court we were taking their November 25th ruling into account, but show the court that we had into account. California took a very different approach in Tandon a few months later. And this is a case, a shadow docket case, that I think really demonstrated where the court made new law. So this is from the court's opinion in Tandon, again, issued a day after California's response. And they said, they announced this principle that government regulations are not neutral and generally applicable whenever they treat any comparable secular activity more favorably than religious exercise. So it changed from looking at the regulation to looking at how it is implemented. And this Fulton is an example of this principle coming to play. But if there is a possibility for different treatment, it is no longer a rule that falls within Employment Division v. Smith. And I think is a significant narrowing of that principle in that rule, and is a significant expansion of free exercise. But what is remarkable about Tandon is that if you look, the only case they cite for this established principle is another Shadow Docket case, the Roman Catholic Diocese case. And then if you go to the next, to the conclusion of Tandon, they basically call out the Ninth Circuit and say, this is the fifth time we've summarily rejected the Ninth Circuit's analysis of California's COVID restrictions. They list all the Shadow Docket cases. And it's unsurprising that such litigants are entitled to relief. And I think this goes to show how empowered they are to use the Shadow Docket to do what would normally be called error correction, but to really step into disputes that the court didn't necessarily step into in times past, but they're now much more engaged in. And in fact, a lot of the coverage of the term this year has been on how much the court has agreed with itself. It hasn't been as partisan. I think the last few cases that Helen talked about dispute that characterization. But this is a chart put together by Steve Laddick, who's a professor at University of Texas, where he looked at where are the liberals dissenting. And of these 31 cases, the overwhelming majority of these cases are Shadow Docket cases. And what this means is that the court is taking action and issuing rulings, addressing litigation that comes before it on the Shadow Docket, where the liberals are not going along with it, are really frustrated by the conduct. But way more of the liberals in dissent occurred in the Shadow Docket case than on the court's traditional merits docket this year. And I think the 6-3 court with Justice Barrett replacing Justice Ginsburg really makes a big difference in how the Shadow Docket is going to work. And if you think about sort of the normal rules are, it's 4 justices is what it takes to grant certiorari to hear a case. And then 5 justices theoretically can summarily reverse a case if they want. But in that circumstance, and we saw this occur a few times in the past, that the 4 dissenting justices would often vote to grant cert in order to have it be a full, in the open, this is what's going to happen, and require argument briefing, and require the court to sort of take ownership of it in a way. When you have a 6-3 split on the court, it's much easier for the court to summarily reverse, to issue these opinions late at night very quickly that don't necessarily get the same attention and press coverage, but often, particularly for the litigants involved, and even more generally, can create real changes in the way in which the court interacts with the legal system. And so I expect to see, as long as the court stays 6-3, that we will see a significant expansion of the court's willingness to take cases and summarily address them than we have in the past, and that the court has sent signals that it really is interested in doing so and invited litigants to come before it quite a bit doing that. And I think in terms of lessons learned from the Shadow Docket that we learned this year, I think there's really 3 important ones that apply to all of what we do. One is you really got to read the room, understand what's important to the decision maker you're appearing in front of. Here, we knew that it was not effective to cite Justice Scalia in Employment Division v. Smith to this court and say, this is neutral, generally applicable, nothing to see here. That's what California did, and they got reversed 4 times. You really have to show the court that you're sensitive to their concerns. The Supreme Court gives us lots of tea leaves, but even with a regular judge, understand what those concerns are and figure out how you can best position your argument. The second is sometimes that requires really communicating with your client and telling them that they need to understand what the stakes are and how the court was going to look at your issue. And sometimes that means pushing your client places that they might not want to go, but understanding that this is how it works, and having that candid conversation, again, without disclosing any attorney-client privileges with the governor's office, but we were able to position Colorado to show the court we understood their concerns rather than just tell them. And that made a big difference in the outcome we had. And finally, this is reminder number 7,000, that it is never just the judge, that the people who work around the court and around the judge make all the difference in how they frame the issues, how they talk about your issues and your case and just be polite, answer the phone late at night if it's the court calling, and do all the little things to treat the people around the court with dignity, empathy, and respect, and it will come back to really benefit you. Quickly turning to the next issue I want to talk about with NCAA v. Olson, and I think this is a case, again, of sort of the opposite approach. One would be summing up what the Supreme Court did. I think this is the largest beneficiary of the NCAA's rules on amateur athletics. This is the coach of Nick Saban, the coach of Alabama, makes $10 million a year off of the labor of a bunch of students that don't get paid anything. And the NCAA sort of walked into court very arrogant. They came to our office very arrogant and asked for our support in their position. And there was a real sense of entitlement and, we've done this forever. We will be able to keep doing this forever. Are you with us or against us? They, I don't think, recognized what happened. And at the court, the argument went very poorly. It was a unanimous opinion rejecting their position. And two things of note in this opinion, I think, that give us all lessons. One is the trial below was a mixed bag. Some of the provisions were upheld. Some of the provisions that the NCAA has were thrown out. The players didn't appeal. The student athletes didn't appeal. They took their somewhat of a victory and said, it's not going to get better at the Supreme Court. The NCAA appealed everything, and it did not go well for them by any metric. The nine justices ruled against them, and then Justice Kavanaugh, in a concurrence, basically said, in very biting language, with surprising success, the NCAA has a long shielded its compensation rules from ordinary antitrust scrutiny. I add this concurring opinion to underscore that the NCAA's remaining compensation rules raise serious questions under the antitrust law, inviting a challenge. And I think in the NCAA's world, there's no real effort to recognize there may be a middle ground or we have some judgment, and they're much worse off than they were. They had just not even appealed the earlier trial outcome. So again, the lessons from the NCAA, read the room, understand who's going to be deciding and what they think about you, and also really communicate with your client. It was clear that the NCAA as a client had a level of arrogance that was unchecked by its counsel. And I think it really paid the price at the Supreme Court. I'll turn it over to the next folks and look forward to more discussion. But thanks again, everyone, for being with us. And again, welcome to Inniss.
Thank you so much, Mr. Olson. Next, we have Mr. Van Oort.
Well, before I start, thanks so much, too, for inviting me back here. I want to follow up with Eric, though, on the expansion of the Shadow Docket, because it's an open question to me just how much it will expand. Back when I was clerking there, it was largely comprised of, stay of execution things. That's mostly was done. And then there are a few cases where somebody would get summarily reversed for not following arbitration decisions. And, and that's kind of how it stayed and began. And then the United States started using it a little bit more. But the two recent, the big surges were one in the election law context leading up to the election where there was this real timing crunch. And you could understand something had to be done if they're going to do it all. And then in the COVID emergency with religion. What I wonder is, are they really going to start making a lot of use beyond either historic categories of the stay of execution and arbitration, where there isn't the same sense of time urgency? I could see this as maybe incrementally changing it, but being more of a blip and then reverting to normal. What do you think?
I actually think it's going to be a pretty significant increase. A lot of the COVID cases really had no legitimate urgency, right? They were, early on it was, we're having church on Sunday, we need a decision by then. But after that, there was sort of a 2 to 3 week briefing schedule for most of them. And the court seemed willing to indulge that vehicle towards mechanisms, or that vehicle to resolve disputes. So I think it's here to stay. And until there's a significant reduction in their willingness to hear these cases, I think we're going to see litigants pile on.
Well, I certainly think people are going to try. At this point, you need to try in some circumstances if you're watching this. So, well, I'm going to share my screen here a second, and then we'll get going. And what I'm going to do is organize. I'm going to go through 3 cases. There are a lot of very significant commercial cases this term, but I'm going to go through 3 of them that kind of fit into that category, but with a very particular frame on that. And that is the frame of discussing how Justice Ginsburg leaving the court and how Justice Barrett joining it may be shaping what the court is doing. First, you just got to start with pausing and recognizing Justice Ginsburg. It shocks me to remember that it has been less than a year since she left the court. It seems like 5 years. I couldn't actually believe when I went back and was reading these that Justice Barrett didn't join the court until October of last year. And there are a number of these decisions where she didn't participate. It just, COVID time is weird time. And in this case, it extended. But, Justice Ginsburg had such a remarkable career and ended up being the first woman to lie in state at the Capitol and had a really profound influence on the court. Another, just fun memory, it's well known that she and Justice Scalia were very, very close friends, despite being, real ideological opposites on a lot of things. And one of the best stories coming out of this is Judge Sutton, who clerked for Scalia, was walking into his chamber shortly before he died, and he saw 24 roses there. And he asked what they were about. And Scalia said, well, they're for Ruth's birthday. And Sutton exclaimed, he said, I don't know that I've ever given my wife 24 roses in our entire marriage. And Scalia said, well, you ought to try it sometime. And then Sutton, feeling defensive, said, well, what have you ever gotten from all those roses? Name one close case, 5-4, where you ever got her vote. And Scalia's response was, Jeff, some things are more important than votes. And it's just such a touching story to see how they did that. And for me, not only did she stand for somebody who had such courage, but then was also a model of how to get together, especially when things are so rancorous. So, but she left the court, and then Justice Barrett, of course, was there. And Justice Barrett, the first justice now who's not a Harvard or Yale graduate, she's a Notre Dame graduate, the first mother of school-age children who's been on the court. She was a Scalia clerk 2 years before me, and she said, that she really agrees with the way Scalia approaches a lot of these things. And so this is a big shift. This is not a Kennedy to Kavanaugh sort of a shift, or Kennedy Gorsuch. This is a very big shift. And so now let's play through how some of these happen. The first case is a personal jurisdiction case. And this one isn't so much a shift from Justice Ginsburg to Justice Barrett, because Justice Barrett didn't take part yet. It was too soon. More what happened here, though, is Justice Ginsburg had been the architect of personal jurisdiction doctrine the whole time she'd been on the court. And there are these nice, clear rules. There's general jurisdiction. You can be, if you're a company, you can be sued for anything, no matter how it relates to your state, in the state where you're incorporated and have your principal place of business. But other than that, you could only be sued in other states if the case had a connection to what you were being sued about. And the court had developed these rules over time. There's a little bit of strangeness in that doctrine, though, because personal jurisdiction asks, does the court have power to act over the defendant? But in these specific jurisdiction cases, they're always asking more about the plaintiff. What did the plaintiff connect to the state, and what happened to the plaintiff there? And you're like, well, why? I I would find myself getting confused sometimes trying to figure this out. And it seems that, the court too was confused on that. At any rate, we got this case in the Ford case, and in each case the circumstances were the same. A plaintiff who had been driving a Ford vehicle got injured in a state. One was in Minnesota, one was in Montana. And they sued Ford in the state where they got injured, but they hadn't bought the vehicle in that state, and the vehicle hadn't been designed or manufactured in that state. But Ford sold a bunch of other vehicles of the same kind in those states, reached out. These were Crown Vics and Explorers. These were not some, unusual low market vehicle. There are a bunch of them there. And the question was there enough of a connection between Ford and the state to be sued there? Like I said, even though the plaintiff's own claims didn't arise out of anything that happened there. These were product defect claims and they weren't designed there. They were manufacturing claims, they weren't manufactured there. So the bottom line holding was yes, you could sue it there. In this, everybody agreed, by the way, on this result, that this was not a split decision there. It was split on the rationale. But here's the fun part, going to Justice Kagan, who was a law professor. Justice Kagan is good at lots and lots of things. And this was Justice Kagan being good at common law, where she goes back to first principles and then she explains and kind of like reassesses what's going on with personal jurisdiction. And what was interesting to me is she teased out there are two basic groups being served by personal jurisdiction. One is the defendants, the other is the states. And she said for the defendants, fairness and fair warning, you got plenty of fair warning and fairness if you get sued in a state for a product that you dump into that state, intentionally sell there, even if the injury doesn't arise out of one of the products you sold there, but sold elsewhere. And she said, that's what fairness is about. It's fair warning and contact. This forum shopping concern, is it broad in a state where you're just picking things? She actually placed that on the interests of the states. She made that a federalism principle and said, the real location of suit is driven by the state as an interest. And she said, when a state citizen gets injured in a state by a product, there's plenty of reason to have it be there. So this explains the difference, by the way, why the court in Bristol-Myers Squibb said people who had been injured by a drug couldn't sue in California, even though lots of the drug was sold in California when they hadn't been injured in California. This now sort of reconciles the law on this. And it's just fascinating. And I really think that Justice Ginsburg leaving the court sort of opened up the whole court to thinking more generally about this and reconsidering it. I'm going to skip over the detailed application here, but basically what it boils down to is this applies to companies yet, not so much individuals. When they serve a market for a product, when they're intentionally selling into a state and it causes injury in that state to a state resident, then there's personal jurisdiction. Nice clear set of rules on that. Let's go to the next case now. And this is an Article 3 standing case dealing with violations of the Fair Debt or the Fair Credit Reporting Act. And this one, the change in justices, I think, affected the outcome because this was a 5-4 decision limiting Article 3 standing. And look who wrote the dissent. It was Justice Thomas, joined by the other 3 members of the liberal court. I do not think Justice Ginsburg would have been over there in the majority where Judge Barrett is. And so this made a difference. And basically, this was a situation saying, when can people sue? Are there constitutional limits on when they can sue, even when Congress has given them a specific right of action? And the court, the majority said there are limits. There has to be some concrete injury that pre-existed it. Congress can make it more specific, but it can't create it out of nothing. That's the majority. And Justice Thomas in dissent said, no, that's not what historically we've done. He said, this is a recent innovation by us. He agrees that there had to be a particular injury. Something that the law prohibited had to happen to the person suing. So you couldn't have some public environmental statute create a citizen suit provision and then just have anybody sue. He said, but that's a particularity requirement, not a concrete injury requirement. The bottom line on this is that companies who get sued for these regulatory statutes, so the court here said, the violation was misidentifying people on a potential terrorism list. They said, if the credit bureaus do that, but don't send the reports to anybody, there's no injury. And then they said there was a formatting requirement in how you had to send credit reports. And they said nobody was injured by that. And so this will have the effect of dampening the types of lawsuits that can be brought for technical violations. And I think the outcome is different. This is not, again, a switch in results. This is where Justice Barrett fits in the court. Helen mentioned at the beginning, Justice Breyer being, characteristically pragmatic, which I agree with. There's a rough split on the court between pragmatists and formalists on that. The Chief, Breyer, Alito, Kavanaugh are all more pragmatists. Sotomayor can go either way, but she's typically more pragmatic. Your formalists, really, Thomas and Gorsuch are strong formalists. It looks like Justice Barrett is more in the formalist mode, like you'd expect from a Scalia clerk. The strange vote here to me is Justice Kagan. But let me just briefly say what this is about. The question here is can the government allow private companies to exercise eminent domain rights against land that a state owns? And a majority said, 5-4 majority said, yes, the federal government can give them that right. The dissent, written by Justice Barrett, said no. There was a lot of agreement here. A lot of agreement said the federal government can, of course, exercise eminent domain against the state, and because that's the way our supremacy clause works. And they said the federal government can delegate eminent domain power to private parties, including the right to sue, but the federal government can't abrogate immunity using Article 1. And this left us with the question, what's happening here? Because eminent domain is an Article 1 power. And the real dispute was, did you need to abrogate immunity or not? The Chief Justice told this nice practical story that they've always been able to do this, and it really makes it easier if they can sue, because do you really want private companies just going and sitting on the land and making the state sue them? And Justice Barrett said, well, of course they can do eminent domain, but the method matters. And this is we've never allowed the government to abrogate sovereign immunity through Article 1. The really interesting thing, as I said, she got a pragmatist. She got Justice Kagan. And to me, she is already in her first year as a justice showing a real ability, for this clear logic. You read back and forth between the chief and her, and they're a good match in terms of how they're fighting. So I'm looking forward to how that plays out over the future. And with that, invite comments from everybody. Otherwise, turn it over to you, Dean Inniss.
Thank you so much, Mr. Van Oort. We're going to turn now to Ms. Stevenson to give some remarks.
Thank you so much, Dean Inniss. It's a real honor to be included in this program, and we really look forward to working with you as part of the Denver legal community. I am going to talk today about some Fourth Amendment cases, specifically the prohibition on unreasonable searches and seizures. Those are Caniglia v. Strom, Lange v. California, and Torres v. Madrid. Let's see if we can get some slides going here. There we go. So I wanted to talk about these cases today for a couple of reasons. First of all, I think Fourth Amendment cases tend to be quite interesting with some rowdy facts. And in these cases that the court took up this term, in each of them, the court vacated a lower court decision to rule in favor of an individual's rights and against the state. In two of these cases, the result was unanimous. And in the third, Justice Roberts and Justice Kavanaugh joined with the liberal justices to form the majority. So a good bit of cross-ideological support here for individual rights. And another similarity among these, despite the unanimity of some of these decisions, there are an abundance of concurring opinions that appear to stake out unresolved future areas of dispute. And following up on a year where we have seen such great attention to the proper scope of police power, these opinions seem like they might be laying some groundwork for future cases that would address, hot button issues like when can the state, take control of a person to assess whether they are a risk of suicide, red flag laws, and of course, excessive force by the police. So let me start then with Caniglia v. Strom. Let's give them there we go. So in this case, Mr. Caniglia was having an argument with his wife, and he brought a handgun out of the bedroom and put it on the dining room table and asked his wife to just shoot him now and get it over with. So she left the house and went to spend the night in a hotel. Now, the next morning, she couldn't reach her husband by phone, and she asked the police to do a welfare check. So the officers came to the house with Ms. Caniglia. They spoke to Mr. Caniglia, who said that he was fine and he denied being suicidal. But nevertheless, they said, will you go to the hospital for a psych evaluation? And he agreed on the specific condition that the officers would not take his firearms. And the officers agreed to that. Then, as soon as he had gone in the ambulance away to the hospital, the officers entered his home, searched it, seized his 2 handguns, all without obtaining a warrant. Now, there is a clear exception to a Fourth Amendment warrant requirement for exigent circumstances, but there were no exigent circumstances here. 12 hours had passed since Mr. Caniglia had, made his suicidal statement of intention. He said he was not suicidal at the time. The officers had plenty of time to get a warrant once he had been taken to the hospital. And of course, there were less intrusive things they could have done, like, for example, asking his wife to take possession of the guns. So in light of all that, Mr. Caniglia sued the officers under Section 1983 for violating his Fourth Amendment rights. Now, the officers argued, and the lower courts agreed, that the officers were permitted to conduct this warrantless search and seizure under the community caretaking exception to the Fourth Amendment. And this is a doctrine that had emerged from the 1973 Supreme Court case, KDV Dombrowski. Now, in a very short opinion authored by Justice Thomas, the court unanimously rejected the notion that the phrase community caretaking, as it had been used in Katie, had created any exception that was applicable to searches of a home. In Katie, the officers had searched an impounded vehicle, and the court had sort of mentioned in passing this community caretaking concept, for instance, when police are called to assist motorists on the side of the road who were having trouble, things like that. But they held that this had no application to a home. The oral argument really illustrated, I think, just how extreme the state's position was in this case. So when Chief Justice Roberts asked whether the community caretaking exception would allow officers, for example, to enter a locked yard to rescue a cat that was stuck in a tree, counsel answered that, yes, it would allow that. And then Justice Barrett asked, well, would it allow officers to enter a home where they could see people having a party without masks during COVID times? And counsel said, yes, it would allow that too. And so those answers, I think, seem to be sort of the death knell for any possible community caretaking exception. Now, despite this unanimous opinion, there were 3 concurring opinions, all that seem to be emphasizing that there are many other exceptions to the Fourth Amendment that might allow officers to search a home in particular circumstances that seem to be concerning to the justices, mostly cases of threatened suicide, or the other category of I've fallen and I can't get up, elderly seniors living alone who might not otherwise be able to reach out and ask for help. Justice Alito specifically commented on the question about red flag laws, and also noted open questions about emergency procedures that states have enacted in various different sort of statutory and regulatory ways in terms of when they can do an emergency assessment and seize a person who has expressed an intent of suicidality. And he made clear that the court's opinion in Caniglia did not answer any of those questions. So while the police can conduct a warrantless search of a home to provide emergency aid, there must be a real emergency, not a cat in a tree. And of course, they should always take steps to get a warrant first if they can, and to consider less intrusive options. Next Fourth Amendment case, Lange v. California. In this case, Mr. Lange drove past a police officer playing loud music and honking his horn. The police officer began to follow him, and then about 100 feet from Mr. Lange's house, the officer turned on his lights. Mr. Lange, who did have a blood alcohol content 3 times the legal limit, pulled into his driveway and walked into his garage. And the officer followed him into the garage, gave him a bunch of sobriety tests, and ultimately arrested him for a misdemeanor DUI. Mr. Lange moved to suppress the evidence. And the state argued that the warrantless entry into Mr. Lange's home was justified by this exception I was just talking about. Different exception, exigent circumstances. So this is an exception that if there is an imminent danger, or if there's a real risk that a criminal defendant or suspect is going to destroy evidence, allows the police to proceed without a warrant. And the California Court of Appeals held that the pursuit of a suspected misdemeanor, not a suspected felon, but a suspected misdemeanor, categorically satisfied that exigent circumstances exception. The California Supreme Court denied review, and actually on cert, the state of California declined to even defend the ruling. But once again, the court, in a unanimous opinion that was authored by Justice Kagan, agreed that there was no categorical rule that pursuing a suspected misdemeanor would necessarily constitute exigent circumstances that would permit a warrantless entry into a home. And again, like in Caniglia, the fact that this was the suspect's home was of clear importance to all of the justices. In addition to that, Justice Gorsuch went on his obligatory rant about the fact that pretty much everything these days is a misdemeanor. And numerous justices noted the fact that what is and isn't a misdemeanor varies so much among the different states that it would just be impossible to articulate any categorical rule that would say that pursuing a fleeing misdemeanor would always constitute exigent circumstances. And then finally, Justice Thomas concurred in the judgment to reiterate his view that even if the entry had been unlawful, the evidence still should not be suppressed because suppression of evidence is a prudential doctrine, and the costs of suppressing evidence where a suspect is fleeing are too high. Multiple other justices concurred to also say, while there's no categorical rule that a fleeing misdemeanor would generate exigent circumstances, certainly there are many, many instances in which that would be true. In fact, almost all instances, because there was probably almost always the possibility that that person is going to dispose of evidence or be a danger to themselves or others once they are fleeing from the police. So good luck to Mr. Lange on remand in that case. Finally, talk about the case Torres v. Madrid. In this case, New Mexico state troopers went to an apartment complex in Albuquerque to execute an arrest warrant. And in the parking lot there, they approached Ms. Torres, who was near the apartment where they were going to execute the warrant. And she was climbing into the driver's seat of her car. Now, according to her, believing she was being carjacked, she started to drive away. The officers fired at her 13 times and struck her twice. She then drove 75 miles there, went to the hospital for her gunshot wounds, and then was airlifted back to Albuquerque where she was arrested. Ms. Torres sued the officers under Section 1983, claiming they violated her Fourth Amendment rights by seizing her with excessive force. And the 10th Circuit held that even though Ms. Torres had been shot, there was no seizure under the Fourth Amendment because she continued to flee and was not in the control of the officers. And so the Supreme Court took the case to answer the question of whether the seizure of a person requires that the person continue to be restrained. Chief Justice Roberts authored the majority opinion, holding that yes, indeed, shooting a person is a seizure if it is done with the intent to restrain. Now, Roberts relied first on Justice Scalia's prior opinion from the case California v. Hodari D., as well as the common law of arrest as the framers would have understood it. There was a very big dispute in this case about Hodari D. because although it had addressed the question of whether the mere physical touching of a person was a seizure, had addressed that idea repeatedly and repeatedly said that yes, it was, that particular holding wasn't exactly implicated by the facts of Hodari D. And so there was a great deal of dispute about whether these statements, which appeared many times throughout this short opinion, were or were not dicta. So that was one aspect of the decision. And then the other aspect was whether the common laws as it existed at the time of the framing supported that this type of touching was in fact a seizure. Justice Gorsuch authored a 26-page dissent. And if you are interested in Dickensian debt collection practices, I will recommend to you that dissent. But to sum up and to takeaways from Torres v. Madrid, certainly the court confirmed that an indirect touching can be a seizure. It doesn't have to be an actual grabbing by the police. It can be with a bullet. And, you know, the seizure of a person, one of the major issues for Justice Gorsuch was that the court's definition made it such that the definition of seizure with respect to a person was different from seizure with respect to property or the effects of a person. But as Justice Sotomayor noted, an oral argument, I thought quite eloquently, you know, the Fourth Amendment's protection against seizure of a person, you know, deals with the concept of your bodily autonomy and integrity. And therefore it was appropriate to define it differently than simply the seizure of, you know, personal effects or property. And so while we now know that, you know, the indirect touching of a person, even if they continue to flee after the fact, can be a seizure for Fourth Amendment purposes, this does leave open questions about things like tear gas or flashbang grenades and whether those could be construed to seize a person. Following up on Eric's point about the shadow docket, you know, and the groundwork that this decision is potentially laying for future excessive force cases, I just note that the court very recently issued an opinion, a GVR in the Lombardo case, where the plaintiff had been held in a jail in St. Louis, had been shackled. He was demonstrating violent behavior and potentially self-harm. And the police had gotten him both handcuffed and his feet shackled, but then put him in a prone position where they kept him on his stomach for 15 minutes and he ended up dying. And the court entered an interesting per curiam opinion there, basically saying, we're not sure that the Eighth Circuit adequately considered all of the relevant excessive force factors. So please go back and try again, but without any more guidance than that. But you know, again, I suspect that we will continue to see more challenges to excessive force by the police. And then the last thing that none of these Fourth Amendment cases get to is another, I think, elephant in the room for perhaps the next term or later in the future, which is the question of qualified immunity. So I will stop there with the Fourth Amendment roundup. You know, one thing it's been jumping out to me as we've been talking, and I'd like to hear folks' opinions on is, you know, with this new court, is there an actual, it's not 5-4 anymore, but 6-3 divide, or is there a 3-3-3 divide with Justice Roberts, Kavanaugh, and Barrett somewhere in the middle, being poached to go with either of the other three groups at the further ends of the spectrum? So I'll lob that out for discussion.
Thank you so much, Ms. Stevenson. We're going to turn now to some of the questions from the audience. And we have some questions there. Some are more general questions. Others are for specific speakers. So I'm going to start with one that is aimed, I think, mostly at Professor Norton. And the question refers to the case that some of the media have been calling the vulgar cheerleader cases. I'm sure you've probably seen it referred to as that. And so the question is, do you think that this case really has any implications for people who are working out, who are present, I think, for example, or working outside the school context? So what about outside speech by government employees? I mean, how do you think that that case might speak to that, Professor Norton? And others can jump in as well.
Yeah, thank you. I appreciate and I see the parallel, right? I think the bottom line is that school officials, we can see that sometimes, but not always, students' off-campus speech can interfere with what school officials are legitimately trying to do. And in the government employment context, I think we can also see that sometimes, but not always, public employees' off-duty speech can interfere with what the public employer is legitimately trying to do. But the big question is, how big or small is that universe of off-duty or off-campus speech that really gets in the government's ways? I think that the court is reluctant, even though there are real parallels between the situation, the court, I've never known it to draw from its school cases in deciding its public employee cases or vice versa, for the obvious reason that kids and adults are different in ways that strike us as intuitively mattering. But I do see that where we're going in both cases is appropriately, in my view, a flexible standard. The answer in both those questions is that sometimes, but not most of the time, students' off-campus speech or government employees' off-campus speech can interfere with the government's legitimate interests, but that we should put the government to a heavy burden, or we should require the government to justify its intrusion into that speech.
Do others want to offer a response as well? Or if not, I can turn to the next question. No. Okay, well, the next question is a little bit more general. And so I'll throw this open to everyone. And the question is, do we think, I guess, measuring the temperament of society and the political climate, is there any chance the court will expand to reflect, for example, the number of states that we have now, the growing population in the country, or even the number of circuits that are there? Do we see the court expansion on the horizon?
I'll just weigh in to combine this question with the one that Shannon threw out to us, which is I certainly think there are three members of the court who want to prevent that from happening. And that's sort of the center three of Roberts, Kavanaugh, and Barrett, who very much view the status quo as a wonderful thing and no need to change. I think we saw, including in Justice Alito's 77-page dissent in Fulton, that there's no restraint on his part, and Thomas has been someone who's always spoken his mind, regardless of what the political consequences are. And I think Justice Gorsuch has adopted that approach too. So I think the center three, if you will, are working hard to prevent that from happening. I think the notion that we could effect such a change in our republic it's hard to imagine that it could be pulled off, but I would say the central three are certainly worried about it.
Yeah, it seems Justice Breyer is opposed to the idea too, given what he's publicly said about it. I agree with Eric. It seems to me unlikely. And, some of the metrics, that were suggested is why you would expand it. I don't see why adding more justices would make the court more capable in handling a greater workload. And my friends who clerked like 20 years before me, when they were handling 150 cases a year instead of like 70, say that we're already slackers now, so they sure wouldn't see that justification or any kind of representation. The justices that are picked aren't very representative now in terms of where they come from geographically or anything like that. But I agree. It's really interesting. The Chief Justice, this Chief Justice it's almost like a paradox. He is the most political of all justices that I've seen. in terms of how he chooses to decide cases or what issues he will or won't do. But he's doing it for the purpose of making the court appear less political. And he has a very, very good judgment, I think, for what outcomes will be perceived as political or not. And I think he also accurately perceives that there are so few people in the country who will realize what he's doing on the technical details in order to get there, that the intended effect is being had. And, you know, recent surveys show that more people more recently than ever before view the court as being apolitical or more neutral. Still not everybody, but it's going up. And so it's, like I said, it's this really interesting paradox. And I agree, there are a number of justices on both sides who don't give a rip about, you know, public opinion. They're going to do what they think is right, you know, regardless. And Scalia was certainly one of those, and there are some on both sides. But there is a larger core now that are deciding with a mind toward how the decisions will be perceived, with the chief foremost among them.
Thank you. Here's another question that I think is particularly timely, especially as we here at the University of Colorado and other public schools head back in for the next term. The question is, does the panel think that mandatory vaccination by public entities like colleges and universities is a question that will get to the US Supreme Court? What are some of the issues and points particular to that? And if that question does get there, how might it be decided? And this is for anybody who wants to jump in. It's a tough one, right?
Well, I'll just say briefly, I think we've seen real interest in religious liberty on behalf of this court and free exercise. And I think the most likely way that this gets there is packaged with some sort of religious liberty, free exercise component. So I think so people will certainly try to get there, but I do think, to Aaron's point earlier, that the chief and others will be reluctant to just be seen as taking sides in the, you know, in a culture war as to whether or not vaccinations are good or bad. I think that's something the court would really strive hard to avoid. But if it's packaged in a religious liberty context, I think there's a good chance.
Anyone else? In that case, I'm going to ask a question that I had, and I think I've actually had it for several months now, and it's more general. Mr. Olson, you talked, for example, about some factors that legal advocates ought to have in mind, for example, when they're going before the Supreme Court, or I suppose before any legal tribunal. And you said that advocates need to, quote, read the room, close quote. I'm wondering, how exactly does one do that in a climate of remote hearings? And that's true everywhere from municipal courts all the way up to the Supreme Court. What can some of us do as lawyers to sort of read the room in a world in which the room is virtual? And you can't, for example, see the eye blinks, the eye rolls, the stares, the nods, or any of that necessarily, or at least you can't see them as clearly.
Well, I'll defer to Shannon on this because I think she's had more practical experience in courtrooms than I have over the past year. So Shannon, do you have thoughts or comments on that?
It is a real challenge. I think particularly in terms of deposition taking, is one of the most challenging practical skills to do virtually. But I agree with you, Dean Inniss. I mean, it is a real challenge. And, you know, I think maybe going back to what Eric was talking about before, it's trying to do as much homework ahead of time to anticipate what people might be thinking before you're even there, because it can be so difficult, you know, in this environment to sort of get the human body language feedback that we're normally used to getting when we can see justices sitting on the bench and turning around backwards or not paying attention or rolling their eyes.
And I would add that one benefit of these new Zoom hearings is much more is available on film, on tape. So you can go watch your judge, your decision maker, and get a sense for what you can expect. One of the great things about Colorado courts has been that that's been available here, particularly on the Court of Appeals for quite some time, but it's a real benefit to read the room, to just watch a YouTube argument in front of the court that you're appearing in front of.
And I don't know what others have experienced on this, but I didn't realize until I shifted from live to Zoom and video just how much I relied on body language and how much you can do with body language as an advocate. Like when you're standing there, you're just by turning to one judge or turning to another, or you're like leaning forward or going back, like all of these things that were as intuitive as breathing, that I realized my feeling is that the advocate doesn't have as much ability to influence things by Zoom as live. And the judges treat me more just as an encyclopedia on call, like, hey Siri, hey Aaron, to answer whatever questions they have, than having as much of a conversation. Did you guys, I mean, have you felt anything like that?
Well, I had the opposite. I had my first in-person argument in front of the Colorado Court of Appeals yesterday, and it was like learning a new language, to be there and to be able to turn. It was totally different. So yes, is the answer.
Well, and I thought, our young lawyers who are growing up and having never, they would probably never realize the difference, because when you've got a really great internet feed and video, I mean, this feels great. And you'd never know what you were missing unless you'd been there before.
I have a question now that's directed to a comment that Ms. Stevenson made. And the question is, and anybody else can jump in as well, do we see the court adopting a more plaintiff-friendly approach to qualified immunity cases in light of some of its recent jurisprudence? Any takers?
Since I brought it up, I'll say something. I think there are some tea leaves out there that can be read. I think it could be a weird cross-ideological approach that would get different justices there for different reasons. But my gosh, what an enormous sea change that would be in all of our jurisprudence. It might take some extreme facts and many years of laying the groundwork for that doctrinally to get there. I'd be really interested to hear what Aaron or Eric think, or Helen, people who have maybe followed this issue for a longer time than I have.
I think just briefly, two quick comments. One, I think we see some changes statutorily. So Colorado law has changed now to make it easier to obtain judgments against officers up to a certain amount, but it is a change. And to Shannon's point, we are seeing some shadow dockets and summary reversals from the court where they are policing, I think, overly aggressive findings of qualified immunity and trying to send a signal that the law doesn't go that far, but they're not, I think there's real reluctance, as Shannon said, to formally change the doctrine. I think we're seeing sort of an incremental change in what qualified immunity means. That means on the margins, closer cases will be more likely to proceed, but under the same formal legal framework.
Thank you. And we have a question here for Professor Norton with respect to debate over Section 2 of the Voting Rights Act. And so the question is, Professor Norton and anybody else that wants to jump in here, what do you think is ultimately the nature of the disagreement? Are we talking about disagreement over the role of a discrimination history? Is there a general skepticism towards restrictive voting laws? Is this about textual interpretation? Is this about triggering of strict scrutiny and how and when that happens? In other words, what's the nature of the conflict here ultimately, if you want to opine on that?
Yeah, I think it's a continuation of longstanding disagreements of the role of history, tradition, and custom in both constitutional interpretation and statutory interpretation. Obviously, there's many approaches to textual interpretation, but certainly some number of justices have relied on history, tradition, and custom as a guide to what we should continue to preserve. So under this idea, if presidents have been doing something for a long time, we should be slow today to find this Section 2 violation. Or if we have been historically protecting something as a right, we should be quicker to find it as a fundamental right today than if we have historically regulated that. Folks like Kagan, and I'm with her on this, argue that may have value in many contexts, but that most of equality law is a repudiation of history, tradition, and custom, right? That it is most of equality law, both constitutional and statutory, is a judgment that our history in certain areas is one that we need to scrutinize and reverse. And if that's your view of the purpose of equality law, history, tradition, and custom is a guide to what we should be vigilant about as opposed to what we should protect.
Thank you so much. Wow, I really appreciated that response, as I'm sure our audience did. We are coming near the close of our program, and so I want to throw it open for the last couple of minutes for our panelists to share any closing statements, remarks, observations before we end our program.
Well, Dean Inniss, I'd like to take the opportunity to ask you a question about how you're settling into Colorado and any observations you have about what's next for the court in the upcoming term or things we should all be looking at.
Wow. First of all, I am settling into Colorado delightfully, I must say. As those of you who've met me know, I tend to be tremendously upbeat. And so I am easily delighted, whether it's a trip to the local Costco or meeting our students, faculty, and staff. So thanks for that question. Wow, where do I think the court is going in the next term? It's interesting. I think for me, although I am someone who tends to think fairly, philosophically and substantively, as you might guess from some of my work, I'm also, I think ultimately when it comes to law practice, I'm a real proceduralist and pragmatist. So the first thing I'm thinking about when I look back, for example, over the last court year and where we're going now, I start with things like, how many cases did they do this year versus last year? How many of them were carryovers? How much and to what extent is coronavirus this sort of interesting cloud or frame around the court's actions and what they're thinking about? So the question, for example, that came from a member of the audience about the extent to which or whether the court's going to offer an opinion if the case comes up about mandatory vaccinations. I sit and I ask myself, is this something that the court's going to try to sidestep, or are they going to go straight forward? In short, I think there are going to be a whole lot of sort of procedural, very practical questions that relate to this period that we have just come through, and I might add that we're still going through, because with this Delta variant, I have to say, and I'm sure many would agree, this is one of the most unique social, legal, and economic periods that I'm sure I've experienced in my life. So have many of the rest of us. I don't think there's anyone alive who could point to anything like this, short of a world war or the 1918 flu pandemic. And there's increasingly few people who are alive and remember those. So I would say that if I were going to predict the court's jurisprudence, I'd be sort of standing and thinking about the ways in which they might want to give us guidance that would help us to deal with, as I said, what we've just come through. And that in some respects, I think will be more pragmatic and procedural in terms of how they're thinking about it. Anybody else? Because we are just reaching time. So I want to first and foremost thank all of our tremendous panelists. This has been just a great honor for me to participate as your moderator. I also want to thank our wonderful audience. Thank you for your participation. Thank you for your engagement. You will receive next week a link to the presentation. You'll also have the opportunity to complete a survey, and we very much hope that you will do that. Share your thoughts with us about this program. Those of you who are Colorado attorneys, you'll also get a link for CLE, for your CLE affidavit, and we will be in touch with you regarding future programs. So once again, thank you all so very much. And I look forward to seeing some of you, many of you again on an upcoming program.
Thank you.
Take care.
Thank you.
Bye-bye.